large crowd on hand today for this joint news conference with one of our most valuable partners, the Pretrial Justice Institute of Rockville, Maryland. And I want to welcome especially this impressive group of speakers who's sitting behind me, whom I'll introduce in a few minutes. My fellow Supreme Court justices who are seated here at the table in front of me, here in Frankfurt this week, holding court all week, and arguments today and tomorrow, and conferences all week. There's some of our judges from around the state who are with us today. Our circuit court clerks, some might accuse us of having busted in the crowd, but it just happens to come at a time where they're holding their spring college over at the Keiko building, and so they were kind enough to come over here to be here for this and for an Access to Justice presentation by Justice Keller, which will follow this presentation. But we're really pleased that you all are here to be part of this very special announcement. We have a number of our leadership team and our supervisors with the Department of Pretrial Services from the Administrative Office of Courts. These are the folks who are on the front lines of this initiative with the important work that they do every day. And of course, the reporters who are here to cover this story. All of you all are our guests, and we welcome you to the most beautiful room in the Capitol. Today, I'm honored to announce Kentucky Pretrial Services is joining the other states and taking part in PJI's 3DaysCount campaign. The force behind this important campaign is Cherise Fano-Burdine, who will be speaking to you in just a moment. She's the CEO, Chief Executive Officer of the Pretrial Justice Institute. And I appreciate the work that Ms. Burdine is doing on behalf of pretrial justice reform, and I want to give her a warm welcome to the Commonwealth of Kentucky. As you all know, the goals of pretrial release are to ensure public safety by determining which people should be released from jail and which people should stay in jail pre-trial, and to help ensure that those who are released come back to court. Properly assessing and determining pretrial release is central to our pretrial services function. There's a growing call to reform the ancient money bail system, which can penalize the poor and increase litigation challenging money bail. Kentucky's pretrial services is joining the wave of pretrial justice reform around the country, which is propelling changes in the bail systems all across our nation. 3DaysCount is based on the premise that even 3 days in jail can leave many people less likely to appear in court and more likely to commit new crimes because of the stress that incarceration places on their jobs, their housing, their family connections, and that there are common sense solutions that can lead to more successful outcomes and can actually enhance public safety and the more effective use of public resources. Kentucky's participation in 3DaysCount came about from the work of our Pretrial Bail Practices Committee. Back in 2017, I charged a group of 14 of the Kentucky Circuit and District judges with creating a new risk assessment tool and for recommending ways to improve our current pretrial practices and our court rules in an effort to ensure fair and just pretrial process for all persons. I appreciate the ongoing work of our Pretrial Bail Practices Committee and all of the judges who are working to improve alternatives for pretrial release. As partners with 3DaysCount, Kentucky will have access to the national best practices and support of the Pretrial Justice Institute as we work to educate the judiciary, law enforcement, and all the public about the importance of common sense pretrial justice reform. And now I want to turn the program over to Cherise Fano-Burdine, the CEO of the Pretrial Justice Institute, who may have comments to make. Cherise?
Thank you, Chief Justice Minton and assembled guests. It's It's an honor to be here in a state with a historic and long-standing commitment to pretrial justice, sharing the dais today with many allies. I'm also very cognizant of the fact that one of my bosses is in the room, so I'm on my best behavior. I'll let you figure out who that is. Sometimes it's Lori. I'm here today because the current bail system in America is broken. This isn't the first time you've heard that. Allowing money to determine who stays in jail and who goes home before trial is clearly unfair, but it is also unsafe, expensive, and as we are seeing from a growing number of lawsuits across the country, it is unconstitutional. It is unfair because poor and working class people who don't have money to post bond must stay in jail for days, weeks, and sometimes even months, awaiting their trial. While in jail, they risk losing their jobs, their housing, falling behind in school if they're students. Those with medical needs may not get the needed treatment or medication. In some cases, people may even lose custody of their children because they're in jail before trial. And yet many of these women and men may see their cases dismissed, be found innocent, or spend more time in jail pre-trial than is mandated by the sentence for their low-level offense. This amounts to punishing the poor prior to or in excess of any determination of guilt, something that should never happen in America, where we are innocent until proven guilty. Meanwhile, those with money pay and go home, where they can continue business as usual while also preparing their best possible defense for their day in court. Given this disparity, it is not surprising that research shows people who spend the full amount of time in jail before trial are more likely to be sentenced to jail or prison, and for longer times, than statistically similar individuals who go home before trial. Allowing money to determine who goes home and who must stay is also unsafe, as I mentioned earlier. Research shows that even a short stint in jail, thus the naming of our campaign, even a short time in jail can make some people more dangerous upon release. Compared to a statistically, that's the second time I've used that word, statistically similar person released within 24 hours, someone held in jail 3 days is 40% more likely to be arrested on new charges during the pretrial period. Meanwhile, research has shown that under money-based systems, nearly half of the folks that we might feel are least likely to show up for court and stay out of trouble go home with little to no meaningful supervision. As the head of a national organization that has focused exclusively on pretrial justice for over 40 years, I'm pleased to say that in the recent years, these fundamental, inescapable injustices have been motivating state and local officials all across America to move away from a sole reliance on money bail. In some cases, this move may be led by public servants who would rather see scarce public resources go to schools and hospitals rather than to overcrowded jails. And in other places, growing community of activists are demanding change. And in still more places, reform is actually being forced upon officials by lawsuits that are successfully demonstrating money bond violates the Equal Protection Clause of the 14th Amendment. It is therefore unconstitutional. I should point out that your own Senator, Rand Paul, has co-sponsored national legislation to encourage states to take up this change. 3DaysCount was created to facilitate a voluntary movement away from money bail by supporting the implementation of common sense, systemic, statewide pretrial solutions that can reduce the number of people held in jail before trial while maintaining high levels of court appearance and public safety. The 3DaysCount strategy focuses on 4 basic actions: reducing unnecessary arrests that destabilize people's lives, replacing the money bail system with common sense alternatives, restricting pretrial detention to the small group of people for whom no combination of conditions would secure court appearance or public safety. And the 4th R, raising equity so that all people, black or white, male or female, gay or straight, experience benefits of new practices and policies. Kentucky was on the forefront of bail reform 40 years ago when it abolished the for-profit bail bonding industry. And more recently, its commitment to using data to inform judicial decision-making has kept it on the cutting edge. I talk about Kentucky everywhere I go. In becoming part of 3DaysCount, Kentucky is signaling its continued commitment to best practice as a part of a cohort of similarly forward-thinking states, from Washington on the west coast of this country to New Hampshire on the east. At PJI, we are looking forward to working with the AOC and other committed stakeholders, including members of the community affected by money bail, to identify and support opportunities to make pretrial justice in Kentucky more safe, more fair, and more effective. Thank you.
Also with us today is Jim Milliman, the state director for Senator Rand Paul, who was unable to be with us today. Senator Paul, as Cherie mentioned, sponsored the Pretrial Integrity and Safety Act together with Senator Kamala Harris and supports this national bipartisan bail reform movement. Jim?
Thank you, Mr. Justice. Senator Paul unfortunately could not be here today, but he wanted to very forcefully tell everybody that he totally supports the initiative by Justice Minton, and he is appreciative of the work Justice Minton has done in this horrible situation of pretrial bail by money. This issue arose back in 1964 when then Attorney General Robert Kennedy spoke to the U.S. Senate. And he talked about the lack of equality in our criminal justice system. And he said nowhere is it more needed and more evident than in the bail system. He said that there's a big difference between the rich and the poor in terms of equality. In other words, to put it mildly and put it quickly, the rich pay, the poor stay in our bail system. Nothing had happened since 1964 to fix the bail system. But then one day in 2010, one morning in 2010, in the Bronx, a 16-year-old boy or young man was walking home from a party. His name was Khalif Browder. The police stopped him and said that he had stolen a backpack just maybe a couple days before, a couple weeks before. They took him down to prison, Rikers Island, to process him. He was told there that he would only be there for a few minutes, they would process him and he could go home. This young man stayed in prison for 1,000 days. 1,000 days. He was never adjudicated guilty. He was never tried. He was there for 1,000 days. And during those 1,000 days, he was routinely beaten by his fellow inmates. And many of those beatings occurred in the sight of and with the presence of the prison guards. They stood and watched him get beaten. They had a button they could push to bring other guards in to basically break up any fights. They refused to bring other guards in. And the guards themselves beat this young man mercilessly. And of the 1,000 days that he spent in prison, 800 of those days were spent in solitary confinement. A 16-year-old in solitary confinement, and he hadn't even been proven guilty. And at one time, he attempted suicide by trying to hang himself. He was unsuccessful. And they took him out of solitary confinement when they found out that he had tried to hang himself. They took him out of solitary confinement only to take him out and beat him. And beat him. And beat him. And then they put him back in solitary confinement. We went through that same process 5 times. 5 times this young man tried to commit suicide because of what he was going through. And 5 times they took him out and beat him. Then one day they came to him. We're dropping the charges. You're free to leave. You're a free man. And Khalif walked out of Rikers Island a free man. Maybe the man in him was free, but the mind in him wasn't free. He carried with him the demons of his time in Rikers. And 2 years later, Khalif tried to commit suicide again, tried to hang himself. This time, he got rid of the demons. The suicide attempt was unsuccessful, and he died in 2016. Khalif didn't die in vain. The way he was treated and the situation raised the interest of a lot of people, including Senator Paul. Senator Paul has always been a proponent of justice reform, but this one hit him very hard. And when he died, Senator Paul sent out a tweet praising this young man for the courage and praying for him. This is what has led Senator Paul to work with Senator Harris in California. And it's interesting because if we're ever going to get true justice reform, it has to be done on a bipartisan basis. Justice reform has been tried many times in Congress, only to fail and fail and fail. What we need to do is have bipartisan, nonpartisan support. And that's why Senator Harris of California, who's as far left as you can get, and Rand Paul, who's on this side, have teamed up. And as Justice Minton said, they have proposed, they're co-sponsoring a bill, the Prejudgment, I'm going to get this wrong, Safety and Integrity Act. And what this does, it will free up $6 to $10 million in funds that will be paid for by the Justice Department. There's no new money, it's already been allocated. And this is for grants from states that enact programs which get rid of the bail by money system and go to the individualized system on risk reform, to look at risk and see if this person is going to be a criminal problem when he gets out. Is he going to flee? But is he going to hurt? Is he going to be violent? Is he going to be a threat to his society? These are the adjustments that are made, the decisions that are made. They're not based on money. We have to get the money out of the system and pretrial judgment and decision-making into the system. And Senator Paul, believe me, applauds the work Justice Minton has done. And I thank all of you for your time, and let's get this done. We don't have time to waste. People like Khalif are sitting in prisons today, $45 billion a year. Don't want to talk about the Constitution, talk about money. $45 billion a year is being spent to house people in prison who can't afford bail, but they stay in prison. So Senator Paul implores you, do something. I'm going to have passed out, Field Representative Whitney Meadows is here. She has a summary of the bill that she will give out to everyone. She also has a copy of section 2 of the bill, which explains all the detail. And this gets complicated. And any one of you, Whitney will give you her card, any one of you can feel free to call Whitney Meadows if you have any question about Senator Paul's program. And she will put you in touch with our congressional liaison in Washington, D.C., Aubrey Vaughn, who knows more about this bill than anybody. And so if you have any questions, call her, and she will set up a conference call, and you can have a better explanation of the bill. So thank you very much, and thank you, Justice Minton.
It's been more than a decade since it was necessary to introduce Jason Nemus to anybody in this room, for sure, but I'm going to do it once again. I want to ask State Representative Jason Nemus to speak now. Representative Nemus is a member of the House Judiciary Committee and a strong advocate for common sense justice reform.
As I look into the audience with a lot of friends without robes on, I want to tell you, Mr. Chief Justice, it's a lot less stressful to speak this way in this room. In all seriousness, I want to thank you, Mr. Chief Justice. Chief Justice Minton and the justices of the Kentucky Supreme Court, the judges, prosecutors, circuit clerks, Sharice, a lot of other advocates for doing this work. I believe that one of the biggest problems we have in Kentucky is the destruction of Kentucky families across the Commonwealth of Kentucky. And in order to resolve that, we have to look at the reasons that we as a government are complicit in the destruction of our families. The system doesn't help our folks. The system hurts the least among us. And it is endeavors like this, Chief Justice Minton, that move us forward to helping put back together our broken families. Now, I'm not going to say much more about that because there's a lot of people here who are smarter than me who've already spoken and who will speak in a minute. And I don't want to repeat what they say or take their thunder. I'm here to talk about the budget. I'm on the Appropriations and Revenues Committee in the House of Representatives, and I'm in charge of the Judicial Budget and the Justice Cabinet's budget, which a part of that is the Department of Corrections. And as Sharice said, we are spending our scarce resources on too much on prisons and incarceration. For good or ill, the way it works in the General Assembly is each budget subunit is given a finite amount of money. And in the Justice Cabinet and Court of Justice, we're given about $1.3 billion to pay for all of that. And so if you put money here in circuit clerks, then you don't have that dollar to put in Kentucky State Police. If you put money here in Department of Corrections, then you don't have that dollar to put the Department of Juvenile Justice. So not only are we competing with schools for funding, we're competing in a much more real way for public protection when we put people in jail. Of course, we need to put folks in jail, but we should only have folks in jail, especially pretrial, who are not a danger to themselves and to the community and not a flight risk. It shouldn't be whether they can pay cash bond. So just to put some numbers on what I've said, about $1.3 billion in the Justice Cabinet, 615 of which go to Department of Corrections. About half go to Department of Corrections. $420 million go to the Court of Justice, $280 to State Police, and down the line with Department of Juvenile Justice, Office of Drug Control Policy, and a number of other important functions that the Department or the Justice Cabinet does. They fight for dollars among themselves. Every dollar we spend in prisons, every dollar we spend in jails comes from somewhere else within that very important budget. Included in that is drug treatment. So we need to spend more on drug treatment and less on incarceration, in my view. It also, what is that kind of money got us? It's not enough in and of itself. We have decided this year, I think, in a woefully bad and a heartbreaking decision to reopen private prisons in Kentucky. We've seen that movie and it wasn't good the first time. It's going to be just as bad. This time there's no reason to think otherwise. So we're reopening private prisons in Kentucky because we have an overcrowding problem. But that's not to say that in addition to that, I should say, our jails are overcrowded. In my home county of Jefferson County, if you go there tonight, there will be scores of people, scores of our neighbors and family members sleeping on the floor. Now what they would say is they don't sleep on the floor, they bring boats in, what they call boats. They're about this high off the ground. But to my simple way of thinking, they're not sleeping on the bed, they're sleeping on the floor. Who are we as a people when we put the least among us, many of which haven't even been convicted yet, and we put them on the floor and we don't give them an opportunity to go back to their jobs and go back to their families? So I want to say to Chief Justice Minton a very heartfelt thank you. I will do everything I can do and then some in the General Assembly to get this thing taken care of. This is a part of criminal justice reform, but getting folks out of jail early on so they can get back to their jobs and their families is a very crucial component of that. So Chief Justice Minton, thank you very much for starting this process, and I'll do all I can do to help. Thank you.
I want to welcome Chief Regional District Judge Karen Thomas of Campbell County, who can speak firsthand about how judges care about justice, public safety, and successful outcome for people who come to the courts.
Good afternoon, everyone. I am very excited to be here today as this new and challenging initiative begins. From a judge's perspective, when I think about pretrial release, I think about three things. I think about my community's safety, I think about will the defendant return, and then I think about what the defendant's constitutional rights are and are they protected. By using evidence-based risk assessment tools that are constantly tested and constantly verified and constantly changing for the better, we give a judge a tool in their toolbox so that when they make the call, because believe me, judges make that decision, they have discretion and that should never be taken from them, but it gives them a tool to use in making good decisions when they do make that call. You know, I think one of the things about the criminal justice system should be, and it must do, is it should show even-handed and fair treatment for everyone. And I think when we talk about cash bonds, we ruin that concept. Cash bonds are inherently inequitable. Think about it. When I talk about pretrial release, I always say this, and I always just try to explain my feelings this way. I am a beloved bagel fan. Right? And I know that's a horrible thing to say sometimes. But I love my Bengals. And so let's say I am out after a particularly horrifying loss, any playoff game, that I am upset and I am disorderly and I'm arrested. Right? I've got a good job. I've got friends who have good jobs. I've got family. And they can pay the $500 cash bond the judge put on me so I can get out of jail. Now the guy at the other end of the hallway, he's going to be in a Steelers outfit. He also gets arrested for disorderly conduct. The problem there is this fella is a day worker. He's a member of the working poor. These are folks that if they don't go to work, they don't get paid. They lose their jobs. They lose their housing. This guy doesn't have $500. We are charged with the same crime. We have the exact same background. The exact same criminal offenses, 0, but he stays in jail because he doesn't have money. And I'm out because I do. And my problem with that is that it creates a perception of inequality from the very first contact the defendant has with our court system. And it doesn't promote the belief that our system works and it's fair. Now, I know as a judge from my experience that if you detain someone for even one day, there's this cascading effect, right? If they're day laborers, they lose their jobs. They don't work. And if you can't work, you can't pay car insurance. So then if you hit somebody with your car, you're not insured and that other person suffers. You can't take care of your family. You can't take care of your kids. You can't pay child support. So now all of a sudden they're going to have a felony charge for non-support. We start cascading. These folks then, I think statistically it is shown, are more likely to commit more crimes. Because you know when you have nothing to lose, making bad decisions are a lot easier. Now I just wanted to point out 2 specific categories that I'm very concerned with when we're talking about pretrial detention. One of those are folks that have substance abuse issues. You know, when you detain somebody because they're a substance abuser, we aren't detaining somebody because we are afraid to let them go. We want to manage risk better. Because right now what we manage is we hold them tight and we keep them in prison. We keep them in jails. Prior to the trial, they're not charged with anything yet. But we don't do anything for them either. There's no therapy, there's no treatment, there's no help. They just sit and white knuckle it out. So what happens is when they finally get out of jail, and it's sad to say, but it's been my experience that they get out of jail and they use at the same level they used before, and then they OD. And tragically, some people die. That's not good management of people, of our resources, or of risk. The other type of individual that I'm concerned about are those that suffer from mental illness. You know, mentally ill people can go into a jail because they are in the middle of an episode. They're sick, they're not on their medication. And they go in because they've committed a crime that relates to their mental illness. So we are literally jailing people because they're ill. And we're doing it, right? We're doing it because we don't have anything else to do. Jails are mental health hospitals. And people that go into jails I will tell you whether they're stable, taking medication when they go in, or not stable. They don't say, hey, everybody, I got a mental illness. Because we have shame when it is attached to mental illness. People do not volunteer that information, so as a result, they go down and down and down. And when we release them finally from jail, they haven't had treatment, very little medication, and if they have, it's way expensive for a local budget. They have lost their homes, they've lost their connection to treatment, and they're terribly unstable. And it's a risk to our communities. And I think we need to do something about that when we deal with pretrial justice. We need to make good choices, wise choices, and in terms of what we need to do about use of risk. We need to make wise choices and to be able to effectively manage risk for those people that are in our system. I think treatment's great. I run a felony drug court. I've been involved in mental health courts and veterans courts. I'm a believer in treatment. But none of this is about accountability. Pretrial release isn't about people being accountable. We still have to have people accountable. Nobody's saying these people shouldn't be accountable for activity. But what we're saying is we have to have a better way to look at us than keeping them in jail and making things worse. So I believe that what pretrial justice should do is keep our communities safe, make sure defendants return to court so we can deal with their issues, and we need to make sure the constitutional protections are there. And I believe the 3 Days Count initiative will indeed help you there. Thank you.
Pleased to welcome Kentucky's Public Advocate Damon Preston.
How much is your freedom worth to you? If you were drugged by the government inside a local jail and they said, you can get out, it'll just take some amount of money, how much would you try to get? Would you empty your savings account? If you've got one, would you cash in your retirement? Would you do a home equity loan? How far would you go? Most of us would say we'd go as far as it takes because I don't want to be in jail. As the head of the Public Defender Agency, I can say our clients are no different. The amount of money they can come up with may be different, but their instinct, their desire to be free is the same. So imagine when you're inside the jail, you accumulate that money, you pile it all up. Just figuratively imagine in your mind that you've got an actual pile of cash. And you ask the jailer, can I go free now? And the jailer says, your pile's not big enough. If you had a bigger pile of money, you could go free. But this pile's not big enough, so you've got to stay in jail. How would you feel the system is, what would you feel the system is communicating to you in that moment? Would you think the system is communicating, we want to keep our public safe? Would you think the system's communicating, don't do the crime if you can't do the time? Or is the system communicating the only thing we care about is how big is the pile of cash you can give us? That's the only thing that matters at that point. You haven't been found guilty. All we want to know is, can you come up with the money we're telling you you owe? You know, there used to be a scam email that went around that I would get, and you can imagine that a situation that maybe you've got a relative or a friend who's traveling in a foreign country, and they call you and they say, I've been arrested and I'm in custody, and they're saying, the only way I get out is to pay them money. If you got that call, you'd think, I can't believe the third world's like that. I can't believe there's countries where you just buy your freedom. Doesn't that sound like our system, the way it is? Where the only important thing is, do you have enough money to get out? But the problems with Kentucky's bail system, from our perspective, go beyond that. Let's say that your pile of cash isn't big enough, so they put you in a cell, And a couple of cellmates come along, and they know how the system works. And the first one comes over and says, you know what, it's unfortunate. You were arrested on a Friday night. Had you been arrested on a Thursday night, a different judge in this same district would have set your bond, and they set the bond less. So you would have gotten out if you'd been arrested on Thursday, but because you got the hard judge, you're in. It's really unfortunate you were arrested on the wrong night. And then another cellmate comes to you and says, you know, I heard you were arrested in this zip code. It's really unfortunate that you weren't arrested in this other zip code, because the judges in that zip code are more generous on bond and they would let you out. It's really unfortunate you were arrested on the wrong side of the county line. And you begin to add this up in your head and you think, it's because I don't have enough money. I was arrested in the wrong county. The wrong judge set my bond, and it starts to feel like it's all arbitrary. That is just luck as to who stays in jail and who doesn't stay in jail. From my perspective as the head of the public defender system, that's what it looks like sometimes, because it's a very inconsistent system. You have people charged with very serious offenses that are able to post money and they get out and they go back to their jobs. You have people charged with minor offenses that stay in and they lose their jobs and they can't pay their child support. Their mental health suffers, their physical health suffers, all because they can't pay money. One of the things I'm trying to do as head of our system is to travel around and see how things happen in different courts. And I was in a court last week, and a man came to the podium. He'd been in jail a week, and the public defender said, "Judge, can we get a bond reduction so that he can be out before the next court appearance?" Without any argument, without any debate, the judge said no. And I thought, oh, he must have a high bond. And right after I had the moment to think of that thought, the judge added, bond remains at $300. And he went back out the side of the courtroom into jail because his pile of cash couldn't even total $300. The Department of Public Advocacy is fully behind the 3DaysCount initiative. We think it's time for Kentucky's bond system to be reformed. There are people who need to be in custody, but people who are presumed innocent are not a threat to society. They should be free regardless of how much money they have in their pockets. Their pile of cash shouldn't matter when it comes to their freedom. Thank you.
With us also this afternoon, Jefferson County's Commonwealth's Attorney Tom Wine, a longtime member of the Pretrial Justice Institute board and himself a former judge. So he's well equipped to bring the perspective of a judge, a prosecutor, about the public safety dimension of pretrial release.
You please the court, ladies and gentlemen. Oh, wrong script, sorry about that. I am very pleased to be here today, and I have to kind of issue a disclaimer, first of all, that I do not speak for the Commonwealth Attorneys Associations or the County Attorneys Associations. I only speak for my small piece of the pie, and I hope that with my 36 years experience as a prosecutor and a judge, that I bring to you an idea that is not so new, that idea that people are presumed innocent until proven guilty, but also an idea that we have to change our system because it is broken. During the time that I've served as a prosecutor and a judge, I've seen us go from a system where we set a cash bond fully anticipating that someone would post that bond and come back to court because they didn't want to lose their money, to a system now where we set cash bonds never hoping that they would be able to afford to post that bond so that they would stay incarcerated. As a new prosecutor, I would ask, what type of bond can she or he make, knowing that they were going to post that bond and be out but would come back to court? The concepts under our U.S. Constitution, the Kentucky Constitution, even our criminal rules of procedure, all anticipate three things when we're setting bonds as judges or prosecutors asking for bond. That is that a person will return to court, they will not reoffend, and that we will keep the public safe. And as a prosecutor, I believe that public safety is the #1 priority. But there's a reality that we have to face, and I know Mr. Nemes just referred to it. In Jefferson County and many other counties, our jails are full. In Jefferson County, our jail, which is built to hold just shy of 1,800 people, regularly runs 2,200 people. 2,200 people, which requires us to open an antiquated space over the Louisville Metro Police Department that is unsafe, requires additional help, overtime pay, and Jefferson County pays about $300,000 a month to run that facility. And it's been opened again and again and again. What could we do in Jefferson County with $4 million a year? And Jefferson County is not the only one. Throughout the Commonwealth of Kentucky, most jails are running at about 102% capacity. Think about that, 102%. In Jefferson County, 75 to 80% of the people who are being held in jail are not convicted of anything. They are being held pretrial. If we could just reduce that 75% to 30% or 40%, the money we would save at a rate of about $60 a day per person. Think about that. Statewide, Jefferson County, it's an issue that we have to deal with, and it's an issue more than just the judiciary, it's an issue more than just the legislator, it's an issue more than just the executive, it's all of us together. And that's why I think 3 days count is important. And I think it's also important that we distinguish between those people who are incarcerated post-conviction and are being held, and those who are being held in jail prior to being found guilty. I believe as prosecutors we do a good job in deciding the appropriate penalty and whether or not probation or parole is appropriate, and I think judges do a great job of making that same decision. But it's what happens up front that we need to be talking about, and it's what's happening up front that's causing the problem. We can keep individuals safe that are dangerous to the community by sending them to the penitentiary, but we can also keep people in the community safe pre-trial by deciding who should or should not be released. And I believe that prosecutors need to reevaluate pretrial releases and look to non-cash bonds for non-financial conditions of release. I believe that the Public Safety Assessment Tool, the PSA tool, that's currently employed by Kentucky's pretrial services is effective in determining who is a good risk to return to court and who is not likely to reoffend while they're awaiting trial. The current tool that we use is well designed, as Judge Thomas said, and it is a risk assessment tool that draws on a large set of data. Millions of pieces of information went into that initial tool, and it has been reevaluated since that time with millions more pieces of information. And what we know through AOC is about 88% of the people come back to court and do not reoffend while they're out. 88%. As a judge, if I knew every time I made a decision I was going to be right 88% of the time, I'd be pretty darn happy with that. So we're really making a mistake by thinking we can just incarcerate everyone to protect the community. If public safety or returning to court or not reoffending are the questions, then cash bonds are not the answer. Individuals charged with serious crimes have frequently been able to post high bonds and they're back out on the street. That's no safety issue for us. That's no good safety for us. And simply because some third party or grandma is able to post that $500 bond doesn't make that a safe person to be out on the street because somebody else's grandma doesn't have the money. You know, in Jefferson County, we have anywhere from 20 to 50 people who are sitting in the county jail of a $500 or less bond. And I'm sure in some of your counties it's the same. It's almost, and I say this in tongue-in-cheek, but almost better if the county would post that bond and let them out and save money after 10 days. We are spending a lot of money that can go for a lot of other things by keeping our jails overcrowded. In the end, it really is all about who's got the money. And that's not the best way to protect our community. The drug user who can't post $500 sits in jail. The drug dealer who's got lots of resources and they're not legal posts $25,000 and gets out. Who's the safety risk? You know, there is a slogan, if you can't do the time, don't commit the crime. And I get it, I said it as a prosecutor. But slogans don't solve problems. The problem is we are overcrowded and we're holding in people that after they enter their pleas, one of the most common things for prosecutors and judges to say, I'm now going to let you out till sentencing. If you were a good risk after you pled, you were probably a good risk right up front from the very beginning. And that's something we need to think about. So my plans, and I've talked with our staff, is to work with our prosecutors in Jefferson County to develop a protocol whereby those who are charged with Class D felonies, which are non-sexual or non-violent, and who score low on the risk assessment tool will be released ROR with non-financial conditions imposed. I've already encouraged what we call our rocket docket prosecutors to go ahead and agree to releases for this group of low-risk offenders who are charged with those type of felonies that are low or minimum felonies. Conditions of plea will be that they reappear and they make all courted dates, obviously, and that they commit no new offenses. In addition to setting aside a plea, if they don't appear, they can obviously be charged with bail jumping and face other consequences. We have a lot of tools available to us that we are to be using pretrial. And ultimately, I hope that we're able to convince our legislature and our courts to replace the whole system of cash bail bonds with what we call detention hearings. It works in federal court. The most dangerous people are kept behind bars. The rest can be dealt with. Let them go back to work, wait till we resolve their cases, and impose the punishment that we think is appropriate. We need to save that money. If we could just take 10% of what we're spending and put it into issues like drug rehabilitation, how much more would we save? Ladies and gentlemen, jury is, excuse me, I said ladies and gentlemen, jury again, and I say it not tongue in cheek, but the reality that the public, you are the public, are our jury. You are the ones who are asking us to keep you safe. You are the ones in the public who are asking us to be good stewards of your money. You are the ones who are asking us to protect the rights of the accused. The public is our jury. And so the question is, can we get in front of this problem? As said earlier, in 1976, Kentucky did away with for-profit bail bondsmen, and the system did not collapse. In 2012, we adopted the risk assessment tool by the Arnold Foundation, and the system did not collapse. There are court challenges around the country with the constitutionality of the cash bail system. They are succeeding in those challenges. The question is, can we as law enforcement, as judges, as pretrial services people, legislators, can we get ahead of the curve and come up with a system that's fair to everybody? Thank you.
Finally, it's my pleasure to invite here to the lectern our Christian County jailer and president of the Kentucky Jailers Association, Brad Boyd, who sees every cost to lives and to counties when defendants are unnecessarily detained. Brad?
Thank you for allowing us the opportunity to be here. First, I want to say that Kentucky has it right. Being the only state in the nation that has elected jailers, and having been an elected jailer now for 12 years, as far as I'm concerned, we have it right. Because of that, with the jailers being elected, we are accountable to you, the citizens, that elect us to these positions in our respective counties. And so because of that, it's my privilege to be here today. Kentucky's current county jail system is an example of county government and state government working together to ensure the safety of the citizens in the most cost-effective manner. County jails play an important role in the criminal justice system in order to best protect and serve Kentuckians. We believe some criminal justice reform is necessary. That's why changing to a no-money bail system is a common sense reform that will allow county jails to continue doing their job efficiently and effectively. Judge Thomas talked a few moments ago about the county jails not being mental health institutions and not being basically support or rehabilitative per se for those that are suffering from these substance abuse issues. Unfortunately, across the state, on a day-to-day basis with the opioid epidemic, we are seeing a large number of inmates that are going through the withdrawal symptoms and DTs, and then we also have a large number of inmates who have co-occurring disorders. They have underlying mental health issues that because they are not taking their psychotropic medications, then turn to other forms of medication, those that are illegal, the opioids and other things. So because of that, we certainly are for justice reform because our resources truly are limited. The no money bail reform will allow county jails to focus rehabilitative and protective services to the offenders who need it most. Over the years, jailers and our staff have been asked to do more and more with fewer resources. But reducing recidivism and helping better our communities has been our utmost priority. County jailers and their staff have worked hard to make our facilities constructive and rehabilitative. And I'm proud to say that in recent years, with the help of the state legislators, Representative Nemus and others, we've been able to pass a couple of legislative efforts or bills that have helped that. A couple of years ago, we passed a bill that will allow the county jails, if they choose, you don't have to, but if you choose, you can have a misdemeanor work program, which allows us to work those serving on misdemeanor times to be able to come out and work and then receive credit for the fact that they're working and being, as far as we're concerned, at least productive in their communities or they're at the jail by being a trustee or going out and working in our local communities. And then also within the last couple of years, we had legislation passed that will allow jails and counties that choose to offer reentry programs. They're on a local level. So I basically want to let you all know, the people of Kentucky, your jailers across the state are certainly committed to doing their part to, number one, protect the citizens that have elected them to those positions, offering programming for the inmates that they incarcerate, but also doing our part as far as the criminal justice reform. And so with that, we continue to be innovative and look for programs and find ways to help the citizens and our inmates return to productive members of society. The no money bail, in our opinion, is another step in the right direction to do just that. Thank you.
I want to thank all of these men and women who've come here today to bring their unique perspectives to this topic of pretrial reform, and we look forward to working with all of them to improve pretrial outcomes for the Commonwealth of Kentucky. And I want to thank all of you all for coming here today. At this time, the speakers would be happy to answer questions from members of the press. Tara Blair, if you're here, Executive Director of our Pretrial Services, if you'll come forward, because if they start asking you many hard questions, Tara, I'll turn it over to you. But she is the Director or the Executive Officer of our Pretrial Services Department. So, questions? Yes.
Chief, either you or Mr. Dean, so a year or two from now, can you tell me as specifically as you can what would be different when a judge in Kentucky went to set bail under this new model?
Well, I'm glad you asked that question. We don't bring a particular model to jurisdictions. What we do with jurisdictions is work with them to map out the distance between where they are today and where they'd like to be. So we're looking forward to the coalition at the state level setting their own goals. I can tell you what our goals would be. Our goals at the national level, I said, are about those 4 Rs, right? So we'd like to see a reduction in the number of people being booked into the jails in the first place. And that may mean lots of other supports and services in the community that are taking care of those folks who have mental health or substance abuse issues. We'd like to see a replacement in the money bail system. So what judges would do when they were setting conditions of release would be to encourage folks with conditions that match the level of risk that they provide, that they present. And it would just be removing money from that equation. You'd see a reduction in the jail population of people who were simply there due to an inability to pay. And one of my personal favorites is the ability of judges to actually conduct a preventive detention hearing. That requires all sorts of changes that Kentucky may or may not undertake, but a preventive detention hearing, which happens in the federal system and happens in the District of Columbia and happens in New Jersey, allows for the court to undertake a due process hearing in which the state is required to prove that someone cannot be released because there are no conditions or combination of conditions that would secure their appearance and protect public safety. So in a couple of years, what we hope to see in all of the states that are part of the 3DaysCount campaign and initiative is a reduction in the pretrial incarceration population with no negative impact on public safety or court appearance. And in fact, we imagine over time you'll see an actual improvement in court appearance and public safety.
The only follow-up, someone, I'm sorry, I'm forgetting who, had mentioned the Arnold Foundation's help with the state in 2012. Our judges now use the risk assessment model to determine who's safe to release and who isn't. And I don't know to what extent that has changed things in Kentucky, but
Tara Blair, Tara, I think you can answer that question probably best.
No, it hasn't. The risk assessment is designed as just one tool in the decision-making process. So it measures failure to appear and rearrest. It does not measure flight or danger. That's a judicial determination. So we use the Arnold tool for our administrative release program, which are your low-level, non-violent, non-sexual misdemeanors that score low to moderate, then pretrial releases them. Then we present all the other defendants that have more serious charges or violent charges or score higher to the judges. And that's one tool that they use along with others to make that decision. So it's not the tool that guides the decision. It's just one tool in the toolbox.
Any questions?
Is there any, I know you said about saving a lot of money, but is there any training costs, or how do you get the system up and running for a change like this?
One of the things that Senator Paul's and Senator Harris's bill would do, there would be grants of $6 million to $10 million total that will go to states and counties that adopt this program, essentially adopt this program. It doesn't have to be identical. And those will be used for pilot programs. You know, they'll have the money over a 3-year period to establish a pilot program with the idea that after 3 years, that program, and I'm convinced, that program will prove its worth in both incarceration, in both justice, criminal justice reform, which is badly needed, and also, as I said, over the course of the whole United States, savings would be about $48 billion, that's estimated. So these are pilot projects, and I think after 3 years, they're going to be huge charts.
Mr. Milliman, where does that bill stand right now?
It's been introduced. It now is have to be brought to the floor for a vote. And to be quite honest, there's been a lot of criminal justice reform votes that don't make it through. And so what we're probably going to be doing is asking, as part of the grants, and the grants come out of the Justice Department. Money's already been appropriated in the Justice Department. And we may be calling on all of you for help to get on the phone and not call our representatives necessarily, because they ought to be on board, but other representatives around the country. We have to get this, and it's got to be bipartisan. And so we may be calling on y'all for help. We've got to get this thing passed.
I'm just going to add one thing to your question, ma'am, or to the answer, thank you, is that, you know, Kentucky has a bit of a leg up in this process so compared to other states. You have a statewide system, you have a statewide infrastructure, you have a statewide administrative office of the courts that oversees pretrial services. We're talking about a policy change, and so this is not about spending additional money for additional programming. This is about changing a policy, and you already have in Kentucky much of the infrastructure that's needed to run a system like New Jersey's that doesn't use money bond.
This is for Jason Hughes. Have you got?
I won't yield the floor.
Will you be? No, I should have said the gentleman from Jefferson. Are you going to be introducing anything or pre-filing any legislation next year along these lines?
There will be a number of things introduced by Diane St. Ange and Kim Mosier and myself about criminal justice reform as we did last year, and intend to do it until we get it passed. And then when we get it passed, it's a never-ending thing because you always have to improve the system. The system is very large and made up of thousands and thousands of human beings. So the answer to your question is yes, we're going to move forward on criminal justice reform this coming session.
One of the issues that comes up in the legislature, every few years it passes a criminal justice reform bill to address prison overcrowding. And the numbers don't drop like everyone would like to see, and the response from lawmakers as well. A lot of the important decisions are made by locally elected officials, by circuit and district judges, and by commonwealths and county attorneys, and they don't always go along with what people in Frankfurt ask them to do. So by that token, do you think you're going to be able to get people to follow your recommendations this time if they are locally elected in their own communities and might have their own ideas?
Well, you've identified the challenge. You've asked what everybody's going to be contributing. My contribution would be this: that there's a process I intend to engage our whole system, the judicial branch, in conversation around this topic. I think a lot of it, there's a huge judicial education piece. You know, I myself have been a trial court judge. I have been in the position that many of these judges have been in trying to make these bail decisions. They're not easy decisions to make. So it's all about trying to I did not have, at the time I sat on the trial bench, the use of these tools now that are available. So as we make more information available, more tools available, more education available, it's our hope that we'll be able to make some real change, at least in our piece of the puzzle. Thank you very much. Thank you for coming.